So section 17, 18, 19, and 20. Broadly, section 17 broadly define the specific definition. Section 18 define who is a party to the suit and party to the proceedings. Party to the suit includes agent. Section 18 defines a suit in the representative character also comes within the ambit of party proceedings. The subject matter, a person interested in subject matter comes within party proceedings. A person from whom I derive the interest also comes within the meaning of section 18. Section 19 is dealing with the status of a person. The determination of the status of that person is inevitable, is a must to prove my case. If that person with whom only I am having an identity himself comes before the court and denies my case, I have no case at all. Regarding section 20, I am specifically delegating my knowledge, delegating my right to another person, probably because I am ignorant of the complexities of the issue involved. And I am having absolute true faith and confidence upon another person. I am specifically referring that person. If the person to whom I referred himself denied, then it is an admission. Remember, in admission, two important words are there. The first one is fact in issue, and the second one is relevant fact. If there is no dispute, if there is no issue, there is no question of admission, because the prerequisite of admission is one party advances a case and another party denies that case. When one party admits a case and another party denies the case, an issue arises. When there is an issue, and I am making a statement against my own case, it may be by document, it may be at the time of cross-examination, it may be at any stage of the proceedings, it is an admission. This section is often confused with the section 58. This is the reason why I'm just reading section 58. Section 58 says, fact admitted need not be proved. Fact admitted need not be proved means there is no fact in issue. So I am filing a suit for realization of money. The defendant admits that actually he borrowed an amount and he is bound to pay the amount, but because of financial stagnancy, because of COVID-19 pandemic, I'm not in a position to pay the amount at once. I may be given a short time, a breathing time to pay the amount in installments. There is no fact in issue. The case of the plaintiff is virtually is admitted by the defendant, and what the defendant wants is only a breathing time to pay the debt. Here, section 58 comes into play. A fact which is admitted need not be proved. A fact which is admitted need not be proved under section 58 shall not be confused with the admission comes under section 17, 18, 19, and 20. Sir, I think 30 minutes is over. And I'm afraid whether we can proceed with the confession, because confession is such a long area.
Sir, if we can continue for another 10 minutes, no problem at all.
I have no problem, but the problem is I can't complete within 10 minutes regarding
continuation.
Okay, sir. Now I am coming to the most interesting area, because we know that compared with the civil matters, everybody is interested with crime. Probably because the word confession comes within the wide spectrum of admission. And what is this confession? We are using this word confession in our daily parlance. You may confess so many things, but when you confess something regarding the commission of an offense, when you confess that I have committed an offense, then only the word confession comes under the purview of Evidence Act. Here, the word confession is not specifically defined, because the court only defined the word admission, and confession comes within the wide ambit of admission. But here, section 24 to section 30 is very, very interesting. I am taking section 24 first, because 24 itself is start with a negative section, in the sense confession caused by inducement, threat, or promise when irrelevant in criminal proceedings. So section 24 says that when a person makes a confession, it may be a judicial, it may be an extrajudicial confession. We know that a confession made before a police officer is not at all admissible in evidence, that we will be discussing in the coming section. Anyway, when a confession is made under promise, under threat, or under coercion, it is not at all a confession. But at the very same time, you can see section 28. So instead of reading section 24 separately, I am requesting you to read 24 with section 28. Confession made after removal of impression caused by inducement, threat, or promise is relevant. So when we are discussing confession into section 24 must be read together with section 28. Section 24 says that when a confession is made under promise, under threat, or under promise, threat, or what is the word used? Inducement, it is not a confession. We know these three words because it is very familiar with our Contract Act. When a contract vitiated by fraud, the necessary ingredients are threat, promise, inducement, etc. When an accused, we know a person charged with the commission of an offense by the police or whoever, or even by a judicial officer, and is facing trial, made an admission either because of a promise. A promise means you will be getting something once you admit the offense, or threat or inducement. That confession is not at all a confession. But the beauty of this section is considerably diluted by section 28, because once this threat, the threat, promise, and inducement is fully removed. I don't know how it can be fully removed. Fully removed, it is not a confession. So it's a question of fact whether a promise made by me is not wrong, an inducement made by me is not wrong, a threat made by me is not wrong, prompting you to commit an offense. Prompting you to admit a confession, or prompting you to confess an offense, provided this threat, inducement is completely removed from you. So this is your mental state. At one point of time, I threat you, I induce you, I promise you. At that time, you have not made any confession. After some time, this threat, inducement, and promise is removed. It's a complicated question of fact, your state of mind. You are free from threat, you are free from promise, you are free from inducement. And thereafter, you make a confession. It is a confession. So being a colonial legislation, I think that it is an attempt to harmonize the judicial principle of confession vis-a-vis the colonial perspective of coercive police threatening technique may be diluted in such a way that once it is removed, how can you say that it is removed? It's a question of fact. Okay, so when an extra judicial confession is made, after the removal of any one of these factors, and I can convince the court that at the time of making this extrajudicial confession, I am completely free from the once threat, once promise, and once inducement I had undergone. It is not a confession. The confession is legal, valid, and it can be admitted or admissible in evidence. Okay.
Okay, sir. Clear ആണ്. ഒരു ആർട്ടിക്കിൾ 20 ക്ലോസ് 3 ആയിട്ട് ഇതിനൊക്കെ
20 ക്ലോസ് 3 അതിനെ കണക്റ്റഡ് ആകുന്നുണ്ട്. പക്ഷെ ആർട്ടിക്കിൾ 20 ക്ലോസ് 3 കണക്റ്റഡ് ആകുന്നത് ഈ വിഷയത്തിലല്ല. ബിക്കോസ് ഹിയർ ദ ക്വസ്റ്റ്യൻ ഈസ് When a person, here the question is regarding the mental state of the person. Threat, promise, and inducement is your state of mind. Okay, whether you are influenced by the promise, whether you fear because of the threat. At what point of time threat inducement is removed from your mind is a complicated question of fact. And only when this particular aspect is convinced, this confession is admitted in evidence. Again, just to connect with this, section 29 is very important. Confession otherwise relevant, not to become irrelevant because of promise of secrecy, etc. I'm reading that section so that you will get a clear idea. If such a confession is otherwise relevant, it does not become irrelevant merely because it was made under a promise of secrecy or in consequence of a deception practiced on the accused person for the purpose of obtaining it, or when he was drunk, or when he was made an answer in question which he need not have answered. Here, section 24 is further saying that a person makes a confession for reasons. First one is that I give him a promise of secrecy. I am playing a deceptive technique. Because of that deceptive technique, because of that deception I practiced, the accused fully believing me, fully trusting me, fully having confidence in me, disclose something. I am not bound to keep fidelity with him. I can disclose it to public authorities and the crime can be registered. The second one is that a deception is played. A deception is played in the sense that I am doing some tricks. The tricks, it depends. What is a deception? It all depends. Whatever the deceptive practice I am making, and if the person believes that my deceptive techniques is, he believes in me, and because of the deception, because of the trick I played, he make a statement. Again, it is a confession. Again, when I am in an intoxicated stage, the word used here is drunk, not intoxication. I'm sorry. Drunk is different from intoxication. And we know that intoxication is of different type. When you are undergoing operation, you are intoxicated in a stage of, you are not able to give proper answer to the question. Your mind is not rational. But when you are drunk, we know that when there is an voluntary drinking and you are making some statements. Of course, that also comes within the definition of confession. And lastly, I am not bound to give an answer, but I just give an answer. So during a conversation, I'm not bound to give that answer means when there is some free talk between two persons because of friendship or some other reason. It's not a legal proceedings. It is not in court. It is not an investigation. But in the due course of communication, I am making a statement which I am not bound to disclose to you. Because there is no legal necessary consequence follows for the non-disclosure of my statement. But I'm making such a statement. Then also it amounts to confession. So section 24 starts with a precaution that a confession made under threat, promise, or inducement is not a confession. But at the same time, section 28 says that once this impression is removed, the word here used is fully removed, not simply partially removed. It is not a partial eclipse. It is fully removed. It is a confession. Again, if I am obtaining a confessional statement from you by a deceptive practice under a promise of secrecy, or when you are intoxicated, or answer to a question for which you are not bound to answer, then also it is a confession. Now we have to deal with the most complicated area. I think time is 25, 26, and 27. That is confession made before a police officer, and how much of that confession is admissible in evidence under the controversial section 27 of the Evidence Act.
ഹലോ സാർ.
Hello, sir.
സാർ എനിക്ക് തോന്നുന്നു നമുക്ക് കൺക്ലൂഡ് ചെയ്യാം. ടൈം
conclude ചെയ്യാം, because
40 മിനിറ്റ്സ് ആയിട്ടുണ്ട്.
Yes, more than
So,
40 minutes.
More than 40 minutes. So, any participants, do you have any doubts regarding section 17, section 18, section 19, section 20, and section 58 of Indian Evidence Act with respect to admission? If you have any doubts regarding section 24, 28, and 29 with respect to confession, you can ask.
In fact, sir, section 17 to section 20 covers both admission and confession. Though it basically dealt with admission of a civil nature, it also comes within the wide ambit of confession.
Then, with respect to confession, section 24, section 28, and section 29.
20 things.
So, admission and the evidentiary value of the admission and confession has been mentioned under section. Sir already
Sir,
mentioned
section 17 to section 31.
Section 31, and section 17 to 23 deals with the admission, and section 24 to 31 deals with the confession.
I purposefully not mention section 21 and 22 because we can discuss section 21 and 22 after the completion of the entire section. Because this is the just definitions I am going on after that.
ശരി. അപ്പോൾ സാർ നമുക്ക് അടുത്ത ക്ലാസ്സിൽ we can continue the remaining areas
better,
of admission.
because only after the completion of the entire section we can appreciate the whole concept of admission and confession. Thank you for for your patient listening.
The different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional